for coming to our briefing on human rights in Georgia today. We're very glad to have you all here in this rather cozy setting. I'd like to acknowledge a few special guests. We have Congressman Jim McGovern here, co-chair of the Lantos Human Rights Commission. He has always been a great champion of human rights around the world, and we're very grateful he could make it to be with us today. I'd also like to welcome former Georgian Ambassador Teppo Japaridja. We're very honored to have you here with us today, sir. So what I'd like to do is quickly introduce our panelists, and you should have their bios, more complete bios, on your chairs in front of you, so that's a little bit more information for you. They'll each speak for about 10 to 12 minutes, after which we'll take some questions from the audience. So our first speaker will be Dr. Corey Welts. Dr. Welts is the Associate Director for the Institute for European, Russian, and Eurasian Studies at the George Washington University's Elliott School of International Affairs. He's also an adjunct fellow at the Center for American Progress. Dr. Welts has published extensively in quite a wide variety of journals and also books. You can see a more complete list in your bio packets. We also have Ms. Celeste Drake with us here today. She is a trade and globalization policy specialist at the AFL-CIO who has worked extensively on Georgia. She is a lawyer by training and actually has a background in Congress as well. She was the legislative director for Congresswoman Linda Sanchez from California. And before that, she served as the legislative counsel for Congressman Lloyd Doggett from Texas. And last but not least, we have Ms. Anna Dalidja. She is visiting assistant professor in the Faculty of Law at the University of Western Ontario. She's also a PhD candidate in law at Cornell University. She has worked as a public interest advocate in Georgia, and she was chair of the Georgian Young Lawyers Association, which is a leading human rights organization in the country. So I'm going to ask Dr. Welt to start.
Thank you. Thank you, Danielle. Thank you, Congressman. Thank you to the Lantos Human Rights Commission for convening this briefing on human rights in Georgia. I appreciate the opportunity to join with my fellow panelists in this discussion today. Before commencing, I just want to acknowledge our commemoration today of the attacks of September 11th, victims of those attacks and those who have later fallen and their loved ones. Also, in particular, want to acknowledge the steadfast support and participation of Georgia in the fight against violent extremism and post-conflict operations in Iraq and Afghanistan. In my remarks, I will not provide a comprehensive scorecard of human rights in Georgia today, nor, I should mention, will I be discussing the egregious human rights abuses and violations that have been inflicted on Georgian citizens in territories not under Georgian state control. That's a subject for another discussion. Instead, what I'll do is provide some context for considering the state of human rights in Georgia, including highlighting certain accomplishments. Then, given the timing of this briefing on the eve of a heavily contested parliamentary election, I'll focus on issues that are relevant to the rights of political participation, but which also relate more broadly to the state's ability to cultivate a culture of human rights protection in Georgia. Georgia has made great strides in governance reform over the last 9 years, the era of the Rose Revolution. These have been well documented by observers, including the World Bank, which earlier this year produced a report that many of you may have seen, which called Georgia's transformation since 2003 remarkable, and highlighted what it called 8 areas where anti-corruption reforms have been successful: the patrol police, tax collection, customs, power provision, business deregulation, public and civil registries, university entrance examinations, and municipal services. In 2010, the British news weekly The Economist coined a phrase, the mental revolution, to account for and in part to describe the outcome of such remarkable change. But as I think many of us know, Georgia's transition is very much an ongoing one. It is fashionable for observers of politics in the post-Soviet states to say that the transition from Soviet times is basically over. What you see is what you get. This is arguably not the case for Georgia. Few would say that Georgia has already become a liberal democracy. It remains a kind of semi-democracy at best, in which no electoral transition between a ruling party and its opposition has occurred. The distinction between a ruling party and civil service remains blurred and often non-existent, and branches of government reinforce each other's power more than they provide a balance to power. But this doesn't mean that Georgia has settled into such an equilibrium for the long term, necessarily. Indeed, those who are sympathetic to the Georgian government often argue that fundamental, desirable political and social changes take time. Particularly during this election period, one frequently hears the argument that the enemies of reform are at the gate, that the best chance for Georgia to continue and to consolidate its governance reforms is for the ruling party to stay in power, and that facilitating this outcome is more important than, perhaps even a prerequisite for, ensuring fully democratic politics in the medium to long term. Let me now address some examples of the mental revolution, as the economists refer to it, as they relate to human rights before I discuss certain election-related issues. The examples I want to raise today are not the only indicators of human rights accomplishments in Georgia today, and I also don't mean to imply that substantial challenges in these spheres or others have disappeared. They remain, very much so. These are instead markers that help highlight how far Georgia has come, while also pointing to some ongoing challenges that the state itself faces in human rights protection. First, I'd like to emphasize landmark signs of state tolerance towards religious and sexual minorities. Last year, the Georgian parliament passed legislation granting religious communities, both historic ones and groups that are legally recognized as religious organizations throughout Europe, the right to register as legal entities of public law, something long denied them as the Georgian Orthodox Church retained pride of place. At last, religious minorities, often representing ethnic minorities in Georgia, can say that their state has formally recognized and embraced them, providing a boost to freedom of religious practice and communal security. Then last May, the first ever public march against homophobia occurred in Tbilisi. Police officers on the scene responded to those who opposed the demonstration of a few dozen participants, saying that their job was to secure order and prevent the blocking of traffic, but that they can't ban them from marching. That day, Georgia's public defender, the ombudsman, a state official, issued a statement condemning homophobia and encouraging a culture of tolerance. Both these moves were met with opposition, mass protests against the first, physical altercations with members of an Orthodox religious group in the second, suggesting that in some spheres at least, the government is at the leading edge of human rights protection in Georgia today. Also, any discussion of human rights in Georgia needs to acknowledge the rise of some of the most comprehensive and professional watchdogs of human rights protection in the post-Soviet space. The US State Department's 50-page plus human rights report on Georgia relies heavily on the work of Georgia's own human rights defenders, from the public defender's several hundred-page annual report that it presents to Parliament, to the excellent investigative reporting of Transparency International Georgia, and the notable work of other organizations, such as the Georgian Young Lawyers Association, which Anna Dolidze used to chair, and the Human Rights Center, as well as local branches of Human Rights Watch and Amnesty International. Human rights violations in Georgia are regularly monitored, well documented, conveyed to the relevant government ministries and agencies. The latter often respond to criticism and occasionally redress violations and improve relevant laws. Now for the other side of the coin, I'd like to address two issues in particular of political participation that I would argue also impinge on the ability of the state to cultivate a culture of human rights protection more broadly. The first observation that we've seen in the past year concerns the pervasive role of law, its creation, its interpretation, and its enforcement in serving the government for its political ends, rather than providing an objective context for a political process that impartially, justly, and equitably envelops all political actors. The stripping of the citizenship of opposition leader, and yes, extraordinarily wealthy businessman, Bidzina Ivanishvili, is the most familiar example of this. But its most pervasive reflection has been the way in which the legal system and oversight agencies have gone after the leading Ivanishvili-led opposition and their supporters in what usually is a relatively placid sphere of campaign finance, and it's gone after the opposition with a zealousness ordinarily unseen in this sphere. Multi-million-dollar fines against opposition leaders and parties, the impounding of tens of thousands of DirecTV-like satellite dishes, the freezing of bank accounts, the seizure of assets, the poring over the tax returns of lesser donors, and the summoning of rank-and-file supporters for questioning en masse. All this has already made for a highly disruptive and flawed election campaign and obscured what would otherwise be a natural scrutiny of the ruling party's own use of the powers of incumbency to tilt the playing field in its direction. But this is not all. All of these actions together amount to defining the opposition's determined pursuit of power, a normal and necessary feature of democratic politics, as an inherently criminal act. The second and related observation is that the prosecution of the opposition over the past year has been characterized by the principle of guilty until proven innocent, not the other way around. Investigations in court cases against the opposition have opened and closed at a rapid-fire pace, often in the absence of compelling evidence or via questionable interpretations of law, and they have meted out punishments that far outweigh the seriousness of the alleged crimes. My point is not to say that violations have not occurred. I'm not in a position to be able to determine that, but the systems in place for adjudicating this are sorely lacking, governed by political expediency, and definitely not designed to protect the interests of defendants. In short, the prosecution of the opposition over the past year echoes common complaints regarding the state of the Georgian judiciary in general, whereby prosecutors have a great advantage over the defense. Practically all criminally accused who end up in court are found guilty, a phenomenon helped in large part by the fact that the vast majority of court cases end up in plea bargains. The accused presumably find it easier to plead guilty and to take a reduced punishment than to brave the full wheels of justice. Setting aside the question of whether defendants who plead guilty are in fact such, this reliance on plea bargaining suggests a lag in the development of full judicial procedures, leaving the judicial branch in Georgia to exist in a stunted form. While we look toward Georgia's parliamentary elections next month, we should be as cognizant of the processes that have already helped direct the course of the election, as much as we are of the institutions that will govern Election Day itself, which should be more or less proper, and the platforms and agendas of the contesting political parties. But in the end, rights of political participation and human rights protection more broadly will be best served in Georgia by the rise of an independent, professional, and experienced judiciary that views its role to be not only a facilitator of law and order, but a protector of human rights and a balancer of power. Thank you.
Our next speaker will be Ms. Celeste Drake from the AFL-CIO.
Thank you very much. I'm honored to be here in front of the Lantos Human Rights Commission, and thank you, Danielle and Congressman McGovern, for inviting me to have this opportunity today. The AFL-CIO and its partner, the Solidarity Center, work internationally to promote fundamental labor rights in every country across the globe, and it's through this work that I have come to know the situation for workers across Georgia and have been working to defend the rights of those workers. Following the Rose Revolution of 2003, the Georgian government made a concerted effort to establish a more representative and accountable government. At the same time, the Georgian Trade Union Amalgamation, the only trade union federation in Georgia, also underwent dramatic changes. A new young cadre of trade union activists was elected to the leadership of both the newly renamed Georgian Trade Union Confederation, or GTUC, as well as its single largest union, the Educators and Scientists Free Trade Union of Georgia. However, subsequently, without consulting the trade unions, the government of Georgia quickly passed a new and draconian anti-union, anti-worker labor code. Not only is the government of Georgia enforcing this anti-worker code with apparent enthusiasm, it is interfering with the internal trade union elections, failing to protect workers from both safety hazards on the job and violations of their rights, and refusing to comply with valid dues collection agreements. Unlike Corey, the AFL-CIO has little that it can applaud by way of Georgian defense of labor rights. The AFL-CIO first filed a GSP case. GSP is the Generalized System of Preferences, and it is tariff advantages that developing countries can enjoy, in 2010 regarding the denial of labor rights in Georgia. In order to receive benefits under GSP, countries have to take steps to afford internationally recognized worker rights to their populace. And Georgia, we do not believe, is meeting this standard. The government of Georgia's failures are not a simple matter of legal shortcomings or isolated failures to enforce the law or even a lack of resources. They really imply indifference, not just indifference, but hostility toward labor rights. They are apparently a deliberate effort to deny workers the right to freely associate, organize, and collectively bargain in both the private and the public sectors. The failures are both in the legal regime and in the implementation of that regime. So, for example, the legal regime fails to provide sufficient protection against anti-union discrimination, which means a worker can be fired simply for voicing support for the idea of labor unions. It doesn't even have to be an overt act to organize unions at his or her workplace. The law also fails to adequately prevent child labor, fails to adequately protect the right to strike, and it really puts individual contracts on the same legal level as collective bargaining agreements. All of these things are not appropriate according to the International Labor Organization. It's not just the AFL-CIO talking, but it's the ILO looking at Georgia's laws and saying they don't meet standards. The government of Georgia's abrogation of valid bargaining agreements with its own workers have decimated a number of labor unions. The Railway Workers Union in Georgia is essentially bankrupt at this point because the government has failed to collect dues for its members as promised, and its staff have gone unpaid for 1.5 years. The government of Georgia interferes with union governance. In its response to the AFL-CIO's complaint under the GSP system, Georgia called the unions highly defunct and corrupt. We're not even sure what highly defunct means, but clearly the government of Georgia has taken the point of view that these are not reformed trade unions, that they're not valid, that they don't have a right to exist, and it's taking efforts to destroy them, apparently, where the ILO says governments have to respect the rights of workers to be in unions and to allow the workers to decide when the union is corrupt and when it's not meeting their needs. In particular, the Educators Union is one of the largest unions in Georgia. It was also at the leading edge of reform efforts when the government of Georgia had a candidate that it was pushing for presidency of that particular union. When its candidate did not win, it facilitated an appeal, and the courts in Georgia, interestingly, rather than deciding on it, initially moved the case from the courts where they were to the administrative courts, which was not the correct move under the Georgian legal system. Labor unions are private agencies that should not have been in the administrative courts. With failures to collect dues collection, the government of Georgia indicated that the collective bargaining agreements would have to be renegotiated with each individual school because individual schools were independent of the Ministry of Education. Interestingly enough, Transparency International did a study and determined that individual schools in Georgia are not independent, that they do run at the direction of the Ministry of Education. And as the workers tried to adjust and collect dues individually at the school site, they then encountered interference from principals who were told there can be no dues collection on the school site. And some of the principals admitted they had gotten the instructions to interfere with dues collection from the Ministry of Education, which again brings into question whether or not the schools are in fact independent. The railway workers faced the same thing. There was a national collective bargaining agreement by which the government of Georgia had agreed to collect dues on behalf of the Railway Workers Union. That was abrogated, and as I mentioned before, that union is particularly in trouble. The government of Georgia took a different tack with the Public Servants Union and the Healthcare Workers Union and started either abrogating the dues collection agreement county by county or calling in workers in those particular unions to one-sided meetings where they were told how terrible unions are and asked to sign letters where they were resigning from the union. Because the unions received the letters and they were identical word for word in each case, it was very clear that this was a campaign and that these were not individual decisions to resign the union. In another example of hostility toward trade unions, at the Eurasian Steel Hercules plant, workers struck over pay and safety issues. The police suppressed what seemed to be a legal strike. Workers were told to promise never to engage in union activity again in order to get their jobs back. The few that would not make that promise were harassed by the police. One worker told a story of for the next 30 days, a police officer would wait outside his house, escort him to work, escort him from work, and if he was late, the police officer would knock on his door and say, "Aren't you coming to work today? Let me take you to work." The three leaders of that strike remain unemployed. They were never reinstated, and the plant refuses to give them a letter so that they can fight the reason that they were terminated. They remain in limbo. The government of Georgia has abolished the Labor Inspectorate of Georgia. The police are supposed to have taken over some of the functions of the Labor Inspectorate, but the police have no training in resolving workplace disputes, and in fact, in the example of the Hercules Steel plant, have taken the opposite view and actually actively denied rights and suppressed workers. The government of Georgia no longer provides statistics on workplace deaths. Some industries have been known to be very, very hazardous, particularly mining and construction. So it's not helpful at all to workers who are trying to improve their workplace safety not to have this information. There's a new technical and construction inspectorate, which is supposed to have taken over some of the jurisdiction of labor law violations from the labor inspectorate. It also has no training and no jurisdiction to resolve workplace disputes. And it can only inspect for safety violations, as we understand, after an accident has already occurred, or in cases of immediate threat, such as if a worker thinks there's a gas leak happening right at that moment. The Hercules strike was in part over safety issues, including the fact that workers were not given gloves, boots, adequate safety equipment. And they in particular are suffering because of the lack of a labor inspectorate. And the AFL-CIO knows of no other country that has completely abolished its labor inspectorate. So this really is a unique situation. Finally, when workers raise these issues in Georgia, the place that they go is the Tripartite Commission. And this is a commission of the government, employers, and workers that are supposed to engage in social dialogue and try to resolve these controversies. It was appearing to work at one point in 2008. The Georgian Employers Association and the GTUC came together to put forth some reforms that would have resolved some of the shortcomings, at least in the legal regime, if not in the enforcement regime. Unfortunately, that proposal never went anywhere, and the GEA was replaced on the Tripartite Commission with the Business Association of Georgia, which again testified at the GSP hearing, and it voiced utter contempt for the GTUC, saying that the GTUC was only interested in advantages and rights for union leaders and not for the actual workers. The government of Georgia promised to implement many changes in its law at the GSP hearing, and the Georgian workers and the AFL-CIO are still waiting for those promises to be implemented. It has not cooperated with ILO efforts to establish a mediation program for workers so that some of these issues can be mediated and resolved. We understand that the government of Georgia does talk to the US government and does engage with them on the issues in the GSP petition, but again, workers report that there have been no results, no real progress has been made. Its representatives have said publicly that the laws should first make things easier for employers and only then consider the rights and conditions of workers. We at the AFL-CIO think that that priority is backwards and that the rights and needs of workers should be considered from the beginning. And therefore, workers at the current time have little trust that the situation is going to get better without support from the outside. They're looking to international support for their efforts and really appreciative that there's a whole room full of people here interested in their rights. So thank you very much.
Thank you, Ms. Drake. I'd like to introduce Ms. Anna Delija.
Thank you very much to the Tom Lantos Human Rights Commission for giving me the opportunity to be addressing you today. I am certainly very humbled by this opportunity for two reasons. First, when I personally met Congressman Tom Lantos, that was in 2004, I could not have imagined that one day I would be appearing in front of the commission bearing his name. And second is because today I find myself in an exceptional position because I am speaking about two countries which are very, very dear to me personally. Georgia, my one homeland, and United States, my other homeland. Georgia is the country where I was born, where I was raised, and which provided warmth for me, courage, and aspirations. And this country is the country which provided resources and security for these aspirations to blossom into something that allows me to be here. So I'm very thankful for this opportunity, which I consider very unique for me. Today, I appear before you, people representing American population, because I would like to inform you of the human rights violations that are taking place in the country, which has been dear emotionally and practically for the United States taxpayers and for you. As you're all aware, October 1st is going to be the day which is of great importance to Georgians. It's not just a regular elections. These are going to be the elections which are properly taken advantage of, can serve as a paradigm change. So I would here disagree with economists. Although Georgia has indeed progressed visibly and remarkably, we have not yet achieved a mental change. The paradigm change is still ahead, and only if we're able to get rid of the tradition of usurpation of power, which we've had on October 1st, and there's going to be significant political change, then maybe we're on the way of serious paradigm change. Unfortunately, however, today I don't have good news. I will not repeat too much what has been said by previous speakers, but I would like to speak of, in particular, of 3 areas where human rights violations are more or less evident, and these violations are gained considerable significance because we are in the election cycle in the period leading up to the elections. So first and foremost, it's freedom of association and freedom of expression. Second, the right to vote, or rather the freedom to vote, which includes the right not to vote. And in particular in relation to diaspora, Georgian citizens which are living abroad, and it includes thousands of Georgian citizens that live currently in the United States. And last, but certainly not least, is arbitrary arrest, detention, and lack of fair trials. In relation to freedom of expression and thought, I would like to speak of this on 2 levels. First, individuals who opt for expressing political opinion and who are retributed for their criticisms of the government. And second, largely about the larger structural environment in the country in terms of freedom of the media, empowerment of satellites, and the ability and lack of transparency in media, and severe concentration in media in television media that has greatest influence for Georgian population currently. Polls conducted by the National Democratic Institute one of the latest polls indicate that around 50% of Georgian citizens discuss political questions, issues of political importance. Out of them, approximately 80% individuals discuss political questions at home. So these are 2 separate questions. It's really hard to analyze what does this actually mean. To me, it means most people, around half of the population does not chooses not to discuss political issues publicly, political issues at all, and of those that choose to discuss political issues, most of them do it at home in their kitchens. Why? Because most of them are afraid that their free opinion will be retributed, that they'll suffer. For example, yesterday, September 10th, unidentified persons attacked a family in the village of Tbilistsaro in the Kvareli district, and tried to intimidate the family members. They are plainclothes individuals. They were not wearing uniform, yet armed. The family, interestingly, as a coincidence, had attended a public demonstration of the main opposition party, Georgian Dream, just the day before. The same events take place almost every day in the country. Individuals that choose to express their critical opinion of the government publicly are harassed, retributed immediately, or they or themselves or their relatives. Young Lawyers Association, in its report of 2011, has amply and thoroughly demonstrated that persons who are politically active and vocal will suffer some retribution in form of either informal retribution or criminal punishment under false charges. Second, journalists, especially those that work for TVs allegedly affiliated for opposition parties, are harassed when they perform their daily duties. They're being confronted publicly by identified persons, harassed, and followed to the extent that they cannot perform their duty. Although there have been many complaints, Georgian government continues to maintain that these acts are conducted by private individuals. Even if true, the Georgian government has an obligation and actually is entitled to prosecute interference with the activity of journalists under the Georgian Criminal Code. They have done this so before. Unfortunately, in these cases, when these are journalists who are related to a so-called opposition television station, the government, these law enforcement agencies opt out to do nothing. In terms of media concentration and transparency. You might have heard that the government boasts adoption of certain amendments which fosters allegedly media transparency. Yes, nowadays we know it is offshore, companies registered offshore are not allowed to have any ownership in Georgian media. Nevertheless, this has not helped us to know who are the individuals that own actually the most important TV companies in the country, and here I mean 3 TV companies. However, the links between the public and the private here are extremely blurred to the extent that we can say that these companies are serving directly the interests of the government. The director of the biggest TV company in the country, Imedi TV, is a former minister of the government, and as well as is the former leader of the national movement, the main ruling party in the parliament. At the same time, one of the minority owners of shares in 2 largest TV companies is a business partner of the chairman of the Communications Regulation Commission, the biggest, the most important commission that is charged with regulating media activity and media bias. So they're in the business together. Lastly, the transparency in ownership records does not lead to decrease in concentration of ownership, because 2 largest TV companies, Rustavi TV and NMZ, are 90% and 10% are owned by the same people. So we have a triad of TV companies which are closely related to the government, which are in their political and business interests, and all of this has increasing importance when we are approaching elections. In terms of voting, and here in terms of policy approaches, the Georgian government should adopt a direct prohibition on media concentration, and most importantly, and this is thanks to the US involvement, that we currently have the principle of must carry, then that TV transmission is transmitted, that the government is obliged to provide for TV transmission across the country, and this principle should stay in force after October 1st. That is the time when the most crucial debate on the future of Georgia will ensue. Currently, the principle is supposed to expire on October 1st. In terms of voting, approximately 1/5 of Georgian population, if we count from 2002, is abroad. Many of them are in the United States. Most of them are illegal immigrants. Georgian government, Ministry of Foreign Affairs, adopted a decree in spring of 2012, which makes it obligatory for every person who wants to vote in a foreign consulate to declare their residence status, immigration status in a country. There has been an outpour of immigrants' discontent as a result, because individuals who will come to the embassies and consulates to vote on October 1st, they would have to declare their immigration status, and if they are in this country illegally, they will not risk their lives, their security, and deportation. Therefore, many people resident, including in the United States, will not vote. That removes thousands of individuals from expressing their opinion. On a larger scale, there have been numbers of reports of individuals in Georgia working for banks, construction companies, and public office, complaining that they're pressured by district police, by law enforcement, to go on October 1st and vote for the national movement. These reports have been en masse. And lastly, in terms of issue of arbitrary arrest and detention, it's a great problem. Although, fortunately, we have adopted a new criminal procedural code which brings in many procedural guarantees. Many of them are borrowed from the United States. Many of the procedural guarantees have not been put in place. In particular, they're in relation to individuals who are related to political activity. The right to fair trial, the right to a lawyer, the right to counsel on time are not exercised. As an example, I can give you an example of somebody who's closely related to the opposition party, father-in-law of the chair of Vizina Ivanishvili. He's the primary opposition leader currently of his joint stock company, Kartu, as well as his charity fund. His father-in-law, the father-in-law of this person, was arrested in 4 days after it became public that Vizina Ivanishvili would become a political candidate, a political actor. He was tried for illegal possession of firearms without a lawyer. And although there was also severe other violations, for example, that the main witness was not questioned, although people which are more distantly related to the case have been questioned by the police. Jury trials, which were recently adopted in Georgia, also with, luckily, and thanks to US aid, have changed some things, but the 2 jury trials that have been conducted so far are notorious for their violations. Individual who was a defendant in one case was a main witness in the other case, and most witnesses in both cases are convicts. They're prisoners whose free will, as we know from international human rights law, is constrained because they're already in prison. That's the jury trials. So lastly, in relation to elections, I would like to emphasize that these trends, arrests, and restriction of freedom of expression are particularly worrying when we are facing elections. Because Georgians, as I've heard them recently, I just came back from there, are concerned for their security if they express their opinion. And those individuals who have already expressed their opinion, they are really afraid of the morning of October 2nd. This leads to exacerbation of the situation, radicalization, so that any voice that advocates for a dialogue is marginalized as soft as somebody who is as a voice that risks the security of individuals who have already outed themselves as supporters of the opposition. I think that in order to calm the situation down and create a situation of peaceful political contestation, Georgian government should make a vocal statement that October 2nd will not be a day for political retribution. The videos that have come out of trainings of semi-governmental brigades in the western of Georgia, where they're being trained as individuals armed, we still don't know whether they're paramilitaries or actual security persons who are armed and who are being trained, who voice swearing expressions for the Georgian opposition leader. This is not the first time this is happening in Georgia. Really exacerbate the situation and the fear that if people do not fight to death for their votes, next day, October 2nd, will be dangerous for them and their families. Thank you.